Good morning and welcome to the Morning Scoop for Thursday, June 24th. This is your daily Buckeye fix. I'm Tom Orr. The Minnesota game is in 70 days, the game against Michigan in 156 days. This has been a crazy week in and around the Ohio State football program, so we are just now catching up on another major story that happened earlier this week, the United States Supreme Court case NCAA versus Alston. It is a case we've discussed on the podcast before involving the NCAA's ability to limit the amount of educational expenses student athletes can receive from schools for things like laptop computers. Monday, the Supreme Court issued its decision, and, well, things could have gone better for the NCAA. My guest today is Dan Lust. He's an attorney specializing in sports and entertainment law. He's also the host of the Conduct Detrimental podcast. Glad I don't have to say that. And now I believe this is a new development since the last time we spoke. He's also a professor at New York Law School. So congratulations and welcome back, Professor.
Thank you. Thank you, Tom. Always a pleasure to come on with you. That is fairly new. At the end of May, I got that bestowed on me. And then, I guess life is good right now. Sports law is very busy, and busy is good. So, Tom, my pleasure to come on with you. And I think last time I was on, I think we were discussing this case. So, happy to be back on.
Yeah, you came on the last time right after they had the hearings, the discussion about this, and the oral arguments, and we're discussing the fact that it didn't seem like they went all that well for the NCAA, and then the ruling came down this week, and oh boy, howdy, that didn't go well for the NCAA either. All 9 justices found for Alston. And that made for a lot of, LOL NCAA on Twitter and all that kind of stuff. But, I know that a 5-4 ruling in the Supreme Court is the same in terms of an actual outcome as a 9-0 one, but still 9-0 had to be a real blow to the NCAA.
Yeah, I think it did. And I think in the same sense, right, 5-4 is the same thing as 9-0. This decision, right, as much as it's a fancy 9-0, it really is just an affirmance of the lower court's opinion. So this decision, could have been one word. It could have been affirmed, bingo, bango, bongo, next case. But it was not. You and I spoke offline. I know you've been through the decision, but in total, we have 45 pages, single-spaced between the majority opinion and the concurrence. So, just put it this way, right? 9-0 sends a very clear message. Going above and beyond in a case where you're just affirming also sends a message. A scathing concurrence, which is by no means required. There's no requirement that you have a concurring opinion, which is is the majority opinion. And if anyone else wants to say something else, you can have a concurring opinion. And if you disagree, you can have a dissenting opinion. It was no requirement to have gone as far as they did and to paint that language. So I think the Supreme Court understood the significance of this case to potentially shape the next, we'll say half century of college sports. The last time the Supreme Court touched a college sports case, I know I spoke about it when I was on with you last time, was NCAA versus Board of Regents. And, the NCAA took it up to the Supreme Court, and they got demolished. And what happened? A complete overhauling of the system of TV contracts for sports. So, yeah, I think this case has it's going to have a lot of value in our court system for the next couple decades, and we'll see the impact it has against the end.
You mentioned that concurring opinion from Justice Kavanaugh, and I mean, he got some legitimate mic drop lines. You don't see Supreme Court justices dunking on people all that often, but my personal favorite was, here's a direct quote: "Nowhere else in America can businesses get away with agreeing to not pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate." That because this is a concurring opinion, my understanding is that doesn't actually set precedent. That's just kind of he's almost writing like a blog post or an editorial supporting this decision. But it also kind of seems like it might foreshadow what happened the next time a pay-for-play case comes before that court.
Right. Even if that exact line was in court, such as majority opinion, it doesn't really mean anything. It's a fancy way of saying something called dicta. And it's in the decision, but it's not really the law of the land. The law of the land just is, the only thing that's really, being decided today is the NCAA is restrained on academic compensation. It's a very, very narrow sliver. But, if you're talking about the NCAA's restraints on athlete compensation, you are very close to the world of name, image, and likeness in paying college athletes. So a lot of the commentary in these opinions are touching upon the issue that's going on in the legislature, which I know, you and I have spoke a lot about offline. So, yeah, that line, that was one of the ones that got picked up. But, we're talking about college sports, right? We're talking about, at least in Kavanaugh's comparison, workers and fair market value. That's not something that we've talked about in the sports vernacular, right? College athletes are workers now. College athletes can get fair market value, but that's the world we're about to head into. So, employee benefits, insurance, 401ks, as insane as that sounds, that is the analogous comparison that Kavanaugh is drawing. And, before you say, oh, that's never going to happen, 40 years ago in 1985, when we were looking at the NCAA versus Board of Regents case, we were still in a world where there was the national spotlight game of college football and not really that many other games on television, if any. And that case allowed schools and conferences to open up their own networks and have games on every single channel. And Tom, maybe you're like me. I'm a guy that stays up and watches the late Hawaii game every once in a while. But that world didn't exist where college football is on 100 different time slots in any given network. So that case back in 85 overturned the world of television contracts. So this really does have the potential to do the same for student athletes.
You made a really important point earlier on there, and I want to make sure everyone understands this. Like, the actual case law that was set here is pretty narrow. I saw a lot of people saying like, "Oh, this is it. Amateurism is dead." It's like, no, this doesn't automatically mean amateurism isn't dead. This just centers around those educational expenses, like we mentioned earlier. It does seem to me, and you can again correct me if I'm wrong here, like this is maybe like a crack in the dam for the NCAA. So like, I mean, you can't actually see the water shooting through yet, but you can see that like maybe this is the spot where this could happen soon.
I'd probably go a step further. So, I mean, this is almost like the ominous warning, right? It's almost as if we're in a movie and, the good guy is signaling to the bad guy, like, I'm going to get you. Maybe not today, maybe not tomorrow, but I'm going to get you eventually. The Supreme Court is sending a message to all other courts in the land, right? State court level, federal court level. And they're saying if there's a case that involves the NCAA, this opinion will be decided. I can almost assure you that line at the end of Kavanaugh's concurrence, it says that the NCAA is not above the law, is going to come up by anybody suing the NCAA for the next 50 years, we'll say, until this case gets knocked down. So, and why do I say that? Because that case, NCAA versus Board of Regents, that 85 case, has been cited by both sides, by the NCAA, by the people that go after the NCAA, because you can kind of see it both ways. So, I guess maybe I'll add a little bit of historical context. People looked at that NCAA versus Board of Regents case, and they said, hey, there is a line in here, even though the case was decided against the NCAA, where Justice Stevens essentially said something along the lines of, hey, there may be times where the NCAA's restraint on trade will be allowed. So paraphrasing, but people kind of looked at that as maybe the NCAA will at some point have some sort of a limited antitrust exemption from the courts at some point in time. The NCAA has used that potentially to their advantage, even though I'm not exactly sure what Stevens meant by it. Just me. I mean, I don't know what Kavanaugh meant this time around. But when he says the NCAA is not above the law, period, ends the opinion. There is nothing else to say. The opinion is over. NCAA is not above the law. I think that's Kavanaugh's way of closing this potentially limited antitrust exemption. I know you and I will get into it, but there's a memo that's floating around out now that the Athletic acquired that I think seems to confirm that line of thinking.
Yeah, we are now 1 week away, 1 week today, from the NIL bills going into effect all across the country on July 1st. Ohio's version of the bill is still working its way through the state legislature. Gene Smith, Ryan Day, Cardale Jones all spoke before the state house in support of the bill on Tuesday. But I mean, when this happens, July 1st, this is potentially going to create just complete chaos with 20 or so different laws into effect in different states, others with no law in place. In classic NCAA fashion, after years of saying, oh, we can't do anything about this, they're now making a panic last minute scramble to get something passed before July 1st. You mentioned the memo from NCAA President Mark Emmert leaked out Wednesday afternoon, calling for the NCAA to allow all athletes to monetize their NIL rates starting July 1st on like a temporary basis, an emergency basis. I mean, this is the NCAA saying for years and years and years, we don't need a fire department. And then all of a sudden, their house is on fire. And it's like, oh, we should start pricing out fire trucks. Great work, everyone. Good job. So, I mean, I assume, Dan, if this thing goes into effect, if the NCAA can get this passed in the next week, which I guess is not a guarantee, but if they can, that would at least level the playing field. So if they can get it approved, I assume, though, it would have to be probably about as broadly permissive as possible to avoid coming into conflict with one of the other various laws. I mean, there's 20 or something laws in all these different states. They're all written a little differently. I would assume they have to go basically as broad as possible in terms of rights to avoid coming into conflict with those states. Is that right?
Yeah, I mean, that's the right line of thinking, but I guess easier said than done, right? This is the minefield, and I know you and I have spoke about it, but this is the minefield that the NCAA created for themselves. They had come out with this. We'll say 4 years prior, right after the Ed O'Bannon decision at the Ninth Circuit Court of Appeals that signaled the death of the video game franchise, which Ed O'Bannon won for players, which was fantastic, but unfortunate casualty that EA Sports, their college sports video games were terminated. So I bring that up. The NCAA knew then and there to have probably done something. So, Tom, to the point that you just raised, if the NCAA had just said, we're going to come up with name, image, likeness in 2016, they could do whatever they want. They could make it watered down. They could make it really restrictive. If they had anything, I really highly doubt that California, at the end of 2019 would have felt the need to come out with this fair pay to play legislation and set off these dominoes around the country that all of a sudden brings us to July 1st with various states passing and now a federal bill maybe about to pass, and the NCAA scrambling with less than a week left to try to get this done. So I think the NCAA has got to make their version as watered down as possible. From people that I've spoken to that have been a part of the passage of some of these laws in different states, the state law is going to trump anything that, if there's a conflict with the NCAA, a private organization, state law is going to trump that. So, if they make it a non-watered down version, it's just different than, let's say, for example, the reporting requirements, what you have to tell your university is different in Florida than it is in the NCAA's version of name, image, and likeness. I don't know necessarily if they're going to get sued. Florida doesn't have to listen to them. Florida's going to have to abide by the state law. Just messy. It's just really messy. So I think that's why that line of Kavanaugh's decision, that last one that said, not his decision, his concurring opinion, but the NCAA is not above the law. I think that worried a lot of people in NCAA HQ that if they come up with something, that it will be challenged in the court of law. So remains to be seen, but it's almost like the NCAA's got to pick the red pill and the blue pill, and both are proven. So they got to pick one of them.
Yeah, always brilliant to leave everything to the last possible minute. I know I always do my very best work with, I could have had 30 years to do this instead. Like, well, let's slam this together in a week. Like, absolutely, nothing ever gets missed there. So when you want real detailed work,
it's like college exam time, Tom.
Exactly. Yeah, we're cramming. Mark Emmert is pulling an all-nighter now, trying to figure this out. I mean, if they can't get that passed next week, whether they can't figure out the logistics of it or they can't get it through the Board of Regents or whatever the deal is, what else can they do at this point? I mean, we had talked, I think, at one point about like emergency injunctions in all of these states. I mean, is that a possibility? What other options do they have if they can't get this through?
So Tom, I guess we'll go down the rabbit hole for a second. So Mark Emmert is essentially, Mark Emmert doesn't want to take accountability. Well, let's just say the NCAA. He's kind of a fun punching bag to put at the front of this movement. So he's kind of saying, hey, I'm cramming. We're trying to figure this thing out. Secret memo being leaked, blah, blah, blah. And where was Mark Emmert about 2 weeks ago? He was sitting in front of the Senate at an NIL hearing on June 10th. Mark Emmert, I had a lot of fun with it. And I know, different Congress people and had a lot of fun with it as well. And it was all, as you mentioned, Tom, at the outset, it was a fun LOL NCAA, you guys have no idea what you're doing moment. But what was Mark Emmert doing in a nutshell? Basically begging and pleading the Senate for a bailout from his own incompetence, right? That's essentially what he was asking for. In what other world does an industry leader go to Congress and say, hey, I couldn't figure it out, please bail me out? So just to use our fun, cramming for finals exam metaphor, it's almost as if he's had the whole semester, he hasn't studied a single minute. He starts cramming with a week to go to try to learn the entire course book. And then, right at the last minute, he goes, actually, Congress, can you bail me out of this situation? Can someone else take this test for me, like that college cheating admission scandal? Can someone else sit for this test for me? Because I have no idea what I'm doing, and someone needs to be the olive branch here. So, let's go with door number one to your question, Tom. What could the NCAA do? They could try to light a fire under the federal government to pass that bill, which could be coming. They have to pick one. I know there's as many as 8 bills that are at the federal level. Federal bill gets passed, the NCAA doesn't have to do anything. They don't have to come up with NCAA name, image, and likeness, because that federal bill will trump anything the NCAA does, will trump anything that the state courts do, and then there won't be these 6 states with name, image, and likeness, or name, image, and likeness starting on July 1st. There'll just be the one federal bill. It's the same reason that there's one clean drinking age in our country of 21. Same concept, right? Now, I guess we'll say door number 2, but it's still kind of door number 1. If they need to buy time for the federal government to come up with their name, image, and likeness bill, this federal version, they could file an injunction. And that's a fancy way of saying that they're going to sue the states that have passed name, image, and likeness laws before those things become effective and try to push those dates back. And they would argue, hey, we need an injunction or else irreparable harm would be caused to our institution. And that could be vis-a-vis, kids losing their eligibility potentially, not knowing the rules. recruiting advantages going to the NIL schools over the non-NIL schools. But they could argue that irreparable harm and injunctions, or we'll say emergency relief, that's usually filed on the eve of something happening. Maybe less than a week is not atypical for an emergency order. So at the Senate NIL hearings, the senator over from Hawaii, I'm gonna forget his name, but essentially asked Mark Emmert, "Are you planning to file injunctions?" And Emmert gave some answer, which didn't answer anything. And then
Mark Emmert did what? No, never.
Shocking, right? And then he came back and he goes, "Well, Mr. Emmert, you're here today, sitting before us. Are you leaning towards filing it or not filing it? I need an answer from you. You're right here. Go ahead, Mr. Emmert." So I'm all excited, right? Like, what's he going to say? And Emmert goes, "Well, we've obviously had discussions about it, but a decision has not yet been rendered as of now." A whole lot of hot air. Mark Emmert said absolutely nothing. But reading the tea leaves, it's not someone that said an injunction won't be filed. So I don't mean to press the panic button, but here's me potentially, almost, maybe, possibly pressing the panic button, but I haven't made a decision yet because I'm Mark Emmert. But yeah, those are really your two scenarios. Number one, you get the federal government to get their act together. Number two, you file an injunction to buy yourself some time. And I guess, number three, you pass this interim version of NCAA name, image, likeness to lessen the gap, to continue to buy some time for the state legislatures to figure it out and the federal legislature to figure it out.
All right, I have one more. I'm going to let you go on this one. It feels, just inevitable at this point after the result that we just saw, that the NCAA is going to get challenged in court again on whatever limitations they put in place on NIL, athletes' rights to earn money, maybe from the school directly. Do you see those as areas where they could be vulnerable again at some point, where we could be like NIL passes and then we're relitigating this whole thing about, their employees 5-10 years from now? Is that something that you think is a possibility?
Yeah, 100%. Yeah, I don't see why not. And then so Mark Emmert had that line, right? Like the NCAA's the loss in Alston, little weight should be giving to that concurring opinion. That concurring opinion is going to be cited in thousands of cases. So I'm not sure what Mark Emmert means by little weight, or whoever was paraphrasing his comments, but listen, what did NCAA versus Alston do? It carved out it really kind of ended a very limited restraint that the NCAA had over academic compensation. It was not a question of whether student athletes are employees. It wasn't a question as to whether or not student athletes have the ability to unionize. It wasn't anything like that. It talked a lot about those same tones. And why does a court do that? Not just a Supreme Court, but any court, a higher court, an appellate court, or a Supreme Court at a state court level. They do that to guide future cases that maybe aren't exactly on point, but they make the language a little bit more broad to not just decide one little minute, finite, specific issue. They want to have language because it's important to guide people moving forward, but how the rest of the landscape will come into play. So yeah, there's definitely a world where the question of NCAA versus the employee question comes up. I certainly can see that. And rest assured, this NCAA versus Alston opinion is much closer to being on point than the Board of Regents case 40 years prior. So, I would be surprised if we did not have the case, especially with the way that decision went. People are going to be, we'll say, empowered to challenge the NCAA, to take this to court, because now they have this favorable language on their side. So I love Mark Emmert's comment. This wasn't a big deal. Don't worry. It's not, don't buy the headlines. It's not that big of a deal. No, this is a big deal, and it's going to, I think, increase the amount of litigation against the NCAA. And people that spend money to pay for lawyers to sue the NCAA, maybe they'll feel a little bit more confident that they'll win their case at the end of the day because of that scathing opinion and some of that scathing language featured, amongst the Gorsuch majority opinion as well as the concurrence.
Well, you are always one of my favorite follows on Twitter, and this week especially, there's been a lot to talk about this week. So let people know where they can find you on Twitter, and also go ahead and plug the podcast, because that has been must listen this year throughout all of this stuff as well.
Yes. So we had podcast, it's Conduct Detrimental. I hosted with a fellow sports lawyer and a professor, Dan Wallach. We recapped the Senate on NIL hearings about 2 weeks ago. If you're into getting into the sports law field, we had another sports lawyer on talk about how to build your resume, all that fun stuff. And then this past week, obviously, we covered, the Supreme Court decision. I am at Sports Law Lust on Twitter, and also Tom for the youngins. I'm on Instagram, not quite TikTok, maybe at some point in time, but right now, Twitter, Instagram, and I guess LinkedIn, if you're a professional, over there as well.
All right. Well, really appreciate you taking the time. I know this has been a busy week, but always Always glad to get your insight on this stuff because I think people are slowly figuring out like, oh, this really is as big a deal as they've been talking about for a while. So appreciate you coming on to talk about it.
I've had it circled on my calendar, July 1st in big red pen. So everyone's going to catch up to that. But yes, Tom, always a pleasure. Happy to come on anytime.
All right, and thanks again to Dan for joining us. He is one of my favorite guests. We don't have to break glass in case of emergency with him very often, but when there is major sports law stuff going on, he is always my go-to. Does a great job explaining all that stuff. Really appreciate his insight, and definitely do give him a follow on Twitter and Instagram and LinkedIn. Sports Law Lust, L-U-S-T is his last name. Sports Law Lust. You can follow him there. Great follow. Check out that Conduct Detrimental podcast as well. That is a fantastic listen. This is the stuff that I listen to, so I make sure I know what I'm talking about when I'm talking to you guys. So that's definitely worth a listen as well. So also worth doing is checking out BuckeyeScoop.com. We have a fantastic team of insiders who have just been covering all this incredible news this week, this insane week of JT Tuimoloau's visit, all these camps, tons of 5-star visitors, more 5-star visitors coming this weekend. There is a ton going on right now at Ohio State and in Ohio State athletics, and you can follow it all at BuckeyeScoop.com. Sign up to become a member today. You get access to our Ask the Insiders board and all the other wonderful stuff that comes along with being a member, including an opportunity to win 4 tickets to the Ohio State-Oregon game, courtesy of Nevada Buck. That is, he's probably going to have some pretty fantastic tickets for that. You can win them. All you have to do is be a member before July 4th. So go ahead and sign up today. You'll get a chance to win those tickets. You'll also get up to speed with everything that's going on with JT Tuimoloau this weekend and his Alabama visit, all the other stuff that we're following. It's all at BuckeyeScoop.com. Also, make sure you check out our YouTube channel, youtube.com/BuckeyeScoop. We put up everything there, all of our podcasts, all of our interviews, all of our camp highlights. It's all there, youtube.com/BuckeyeScoop. All you have to do is subscribe and then get notified every time we post a new video. That'll do it for today. Thank you guys for joining us. Have a great day. We'll talk to you tomorrow.